This is Michael Popok, Legal AF. The legal hits just keep on coming for Donald Trump. Even today, the day that he's going to be surrendering, arrested, and arraigned again by Jack Smith, same exact time in his civil cases, his woes continue. E Jean Carroll, a writer and columnist, still has a second defamation case against Donald Trump, dealing with statements he made in 2019 while he was still president that is scheduled to go to trial in just a matter of time in front of the federal judge there, Lewis Kaplan. Today, her lawyers, led by Robbie Kaplan, no relation to the judge, filed a motion for summary judgment, effectively telling the judge that under New York law, which applies, because all of the major issues have already been litigated in the prior case in favor of E Jean Carroll, in which a jury of 9 people found that she was sexually assaulted, that Donald Trump lied, that Donald Trump acted with actual malice when he lied that he didn't know her and had not sexually assaulted or battered her, because that's already been decided. All of the elements of defamation about the 2019 case also, therefore, have been decided under what's a concept called issue preclusion, also sometimes known as res judicata. And under that doctrine applied to these facts, right, the E Jean Carroll's lawyers are saying, Judge, we don't need a trial on anything but damages, including punitive damages. Now, some people might think this case is about statements that were made by Donald Trump in early May, right after the original trial returned a verdict against him and an award of damages for over $5 million. It is not. Those statements in which he at CNN town hall also defamed her, also claimed not to know her, that she was a hoax, that's being used to bolster the request for punitive damages, punishing damages over and above actual damages. But it's not the basis of the new case, which is really the old case or original case. The basis of the new case or original case are statements that were made in 2019 while Donald Trump was still president. And whether those statements were defamatory, whether they had a defamatory meaning, whether they injured E Jean Carroll, and whether they were done with malice. And if they were done with all of those elements, so says the new motion for summary judgment just filed, then we don't need a trial on anything but damages, because liability has already been established or will be established, Judge, once you apply issue preclusion doctrine under New York law to the facts already found by a jury back in May. Let me unpack that on the hot take so that when you walk away from this hot take, you have a really good understanding of both summary judgment law, New York law on issue preclusion, and why Donald Trump will likely lose this particular motion in front of Judge Kaplan. Let's start with the preliminary statement for the motion, which sort of explains it all. I have it here right in my hot little hands. On page 1 in the preliminary statement of the motion, Carroll 1 and Carroll 2, those are the two cases, one dealing with the statements made while he was president, and then the statements made when he stopped being president. That second trial already happened. Both concern the same central question, whether defendant Donald J. Trump sexually assaulted plaintiff E. Jean Carroll. That question has now been answered by the jury in Carroll 2, which found that Trump sexually assaulted Carroll and defamed her after she spoke up. The brief goes on. Because New York law bars the proverbial second bite at the apple, Your Honor, Judge Kaplan, directed the parties to address how doctrines of preclusion, that means you don't get to relitigate the same issue over and over again if it's already been fully and fairly litigated and decided, and it was important to the prior case, and you were there represented with counsel, as good as they may be, then you don't get to relitigate the same issues over and over again, and now take another shot in front of a new jury to deny it all over again. That is barred by the doctrine of issue preclusion. The brief goes on to say that as set forth below, that verdict against Donald Trump 9-0, finding that he sexually abused, battered E. Jean Carroll in that dressing room in 1996, that verdict established numerous critical propositions that now must be taken as true by virtue of issue preclusion. And then they go on to talk about what exactly are the issues that now the judge should take judicial notice of as a matter of law. Particularly, and I'm going to read them for you now. Particularly, they went through the things that should be decisive. And these are the things that they believe the judge should find as a matter of law and not even bother with a jury trial. 1, that Trump sexually abused Carroll. 2, that Trump injured Carroll by sexually abusing her. 3, that Trump's conduct in the sexual abuse of Carroll was willful or wanton, reckless, negligent, or with a conscious disregard of her rights. 4, that Trump's statements that Carroll fabricated her sexual assault were defamatory, because it's not true. 5, that Trump's statement that Carroll fabricated her sexual assault allegation for nefarious purposes was also defamatory. 6, that Trump's statement that he had never met Carroll and that he did not know who she was defamatory. 7, that Carroll was injured by Trump's publication, meaning his announcement to the world through press conference, press releases, tweets, and the like, of the October 2022 statement, right? That was already found, the one after he was president. 8, Trump acted maliciously out of hatred, ill will, or spite, wanton or recklessly for the rights of Carroll when he made that October 2022 statement. And then further, they say that as a matter of law under the doctrine of issue preclusion, the court now should find that Trump's claim that he did not sexually assault Carroll were false. His claim that she fabricated the sexual assault is false. That Trump's claim that Carroll fabricated the assault for some impure purpose was false. The claim that he never met her was false. And that when he made that October 2022 statement, he acted in reckless disregard. And then the leap or the connective tissue between that statement in October 2022 was the foundation of the trial that already happened. And the statements in 2019 while he was president that would be the subject of the new trial. That connective tissue is that they argue in their brief, and I agree with them, that the statements made, no reasonable jury, having concluded that almost identical statements made in 2022 were defamatory, were false, were fabricated, that were done with wanton and malicious disregard for her rights, no reasonable jury would then believe that the statements almost identical in 2019 by Donald Trump somehow don't fit that bill and don't fit the elements of defamation to award damages in the state of New York. So let's skip the second bite of the apple, the second jury, the second presentation, the second chance for Donald Trump to decide whether he's now, having seen what happened with 2020 hindsight, with his master strategy of trying to take down E Jean Carroll through cross-examination and not testify or put on any documents or witnesses himself, including giving a deposition that hanged him in the courtroom. At least the 6 minutes that we've been able to see and read about, we don't give him a do-over, right? This isn't an etch-a-sketch justice system. You lost. And those statements are so perfectly aligned, the 2019 and the 2022, that as for the law, E. Jean Carroll's lawyers argue, we don't give him another trial. That is the foundation of the motion for summary judgment that has been filed. And they go through those facts, which they say are preclusive, barring Donald Trump from relitigating them again. Because, of course, he had counsel, he had the right to testify, which he waived. The same issues were involved in that case. The defamatory statements are almost identical between 2019 and 2022. He published the statements, meaning he told them to third parties. They are defamatory because that jury said those same kind of statements were defamatory. And if anything, Donald Trump is inherently in his DNA consistent in his lying, because he said the same thing in 2019. Not my type. She's a hoax. She's a shakedown artist. She's doing it for the money. The Democrats are putting her up. He has those talking points, those Post-it notes that he uses to make his case that he's still using today. But that's going to hang him because those are identical to the things he said in 2019, which is the basis of this case. Now, Donald Trump will have the opportunity to argue, no, I get a whole new trial. I have to be able to go in front of a whole new jury about liability. It's not just about the money, Your Honor. It's not just about how much I owe in damages, because if that's the case where a jury gets seated and the jury is told, welcome, ladies and gentlemen of the jury, before you got here, me, the person in the black robe, Judge Kaplan, I've already made certain decisions about this case, and I have found against Donald Trump that he defamed published and all the elements of defamation are present. All the elements under New York law. And all you are here to decide, ladies and gentlemen of the jury, is the amount of money that you're going to award for the damages, punitive, punishing damages in the multi-millions, and regular compensatory damages. But you are not to consider whether my decision that under the law, he did defame her and all the elements of defamation are present. You are not to question that. Now let's put on the evidence, call our first witnesses. That's how it's going to go if they win this motion for summary judgment. So Donald Trump will have an opportunity in the next 20 days or so to file an opposition brief and argue why issue preclusion should not be applied and why his 2019 statements are so different than his 2022 statements, even though they're not. He'll create some sort of chart that doesn't make any sense. And then there'll be one more brief, and that'll be E Jean Carroll's. That's called a reply brief. There may or may not be oral argument, meaning the lawyers go into the courtroom and argue, or the judge, as most federal judges do, makes decisions on the papers, meaning without the benefit of oral argument. But we will get a ruling by mid-September on whether we're going to have a trial on liability with Donald Trump in the civil case of defamation, or we're going to go right to damages and punitive damages, and that's all the jury is going to be focused on. I'll follow it on hot takes like this one. One place, MeidasTouch Network. Get it on the YouTube channel. Follow us on Legal AF, the podcast at the intersection of U.S. law and politics that we do every Wednesday and Saturday. Follow me on all things social media at MS Popok. Until the next hot take, this is Michael Popok, Legal AF reporting.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.